case? How can you impose restrictions on what Idaho can criminalize simply because hospitals in Idaho have chosen to participate in Medicare? I don't understand how this squares with the whole theory of the spending clause.
Yes, I don't really understand why we have to address the stabilizing condition if what you say is that nobody has been able to identify a conflict. And on the mental health thing, the SG says, I just picked it up to check footnote 5, Idaho badly errs in asserting that construing EMTALA according to its terms would turn emergency rooms into federal abortion enclaves by allowing pregnancy termination for mental health concerns. So if that's the only space that you can identify where Idaho would preclude an abortion and EMTALA would require one, and the government is saying, no, that's not so, what's the conflict?
Is it also the accepted standard of care when, rather than the woman's life being in peril, the woman's health is in peril? So let's take, all of these cases are rare, but within these rare cases, there's a significant number where the woman is, her life is not in peril, but she's going to lose her reproductive organs. She's going to lose the ability to have children in the future, unless an abortion takes place.
Today, doctors in Idaho and the women in Idaho are in an impossible position. If a woman comes to an emergency room facing a grave threat to her health, but she isn't yet facing death, doctors either have to delay treatment and allow her condition to materially deteriorate, or they're airlifting her out of the state so she can get the emergency care that she needs. One hospital system in Idaho says that right now, it's having to transfer pregnant women in medical crisis out of the state about once every other week. That's untenable, and EMTALA does not countenance it.
So I think that there are two things that are pretty plain on the face of this statute. One is that EMTALA is about the provision of stabilizing care for people who are experiencing emergency medical conditions. That's one thing I think the statute is doing. And I also think that it is operating to displace the prerogatives of hospitals or states or whomever with respect to that fairly narrow slice of the healthcare universe.
We agree that EMTALA does impose a federal stabilization requirement, but the question here is, what is the content of that stabilization requirement? And for that, you have to reference state law. If ER doctors can perform whatever treatment they determine is appropriate, then doctors can ignore not only state abortion laws, but also state regulations on opioid use and informed consent requirements. That turns the presumption against preemption on its head and leaves emergency rooms unregulated under state law. It's unsurprising that no court has endorsed such an expansive view of EMTALA. And until Dobbs, nor had HHS.